Closing arguments are set to begin Monday in the Kyle Rittenhouse murder trial. Prosecutors and defense attorneys are in court today, hashing out the details for next week's jury instructions. The defense wrapped up its case Thursday after a controversial week of testimony. The then 17-year-old Rittenhouse is accused of killing two people and injuring a third during a protest against police brutality in Kenosha, Wisconsin last year. Wright is a professor at the University of Wisconsin School of Law, and he joins us now with more on this trial. Professor Wright, welcome. It's great to have you with us. As I mentioned, attorneys are back in court today. The prosecution is expected to ask for the jury to be allowed to consider lesser charges. So is that a normal course, or is this a sign that the prosecution is feeling that their case isn't strong enough?
I think it's pretty usual, especially when the charge is first-degree intentional homicide. One of the challenges that the prosecution faces is they had a very high burden of proof, both to prove that Mr. Rittenhouse committed the intentional murders, but also they had to disprove his self-defense claim. And so part of what's going on is by giving the jury more options, they're really sort of lowering the threshold for what they had to prove.
And as you'll recall, the defense motioned for a mistrial with prejudice on Wednesday, which, if it were granted, would ensure that this trial could not be retried. So would this weekend break allow the judge more time to consider granting that motion? Is that still on the table?
Yeah, so the judge has reserved the ruling, and so the judge will probably make the decision. My guess is probably Monday. You know, the request for a mistrial is a big deal, especially in a high-profile case. You know, in order to grant the motion, the judge has to feel pretty confident that the alleged misconduct by the prosecutor tainted the trial to such a degree, when you look at the entirety of the entire trial, that it prejudiced Mr. Rittenhouse. And so, you know, the judge will probably need the opportunity to reflect about what's come in and to really assess the damage, if any, of the prosecutor's alleged misconduct.
And Professor Wright, Judge Schroeder has made several controversial remarks during this trial. He banned prosecutors from calling two people Rittenhouse shot and killed in Kenosha victims. And on Thursday, he made an off-color joke about Asian food prior to breaking for lunch. How are all of these different things, you know, taken separately, perhaps are not a big deal, but how are all of these things sort of together impacting the outcome of this trial?
You know, I think taken together, in courts in Wisconsin and across the nation, the judge has a lot of wiggle room in order to decide how to conduct a trial and what evidence comes in and what evidence doesn't come in. And so one of the questions I think especially appellate lawyers like me are looking at is the judge making decisions so far out of the bounds that it really taints the trial, that really denies Mr. Rittenhouse a fair trial? And so a lot of the things that have been going on, I can't say are wrong to such a degree that it prevents the jurors from doing their duty. What I find interesting about a lot of the decisions, especially some of the decisions that have happened in front during the trial, is that the judge has noted that this is a very high-profile trial, that the eyes of the nation are watching, and he's very much concerned about making sure that the public have faith in the trial and the American justice system. And so sometimes I think some of the off-the-cuff comments, the judge perhaps is not furthering himself in that goal.
But you don't think that prosecutors might argue that Judge Schroeder has been, you know, pro-defendant in their closing arguments? You don't think they might throw it in there? I mean, obviously it's a risky move. You don't want to isolate the judge, but they might also make the calculation that it's a risky move not to mention it as well.
You know, I think going after the judge in closing arguments is normally a big no-no. You know, that's not to say that folks don't do it, but I think it would be fairly unusual to go after the judge in closing statements. That's not to say that people haven't done it and haven't tried, but I'd be surprised if the Kenosha prosecutors, who have an existing relationship with this judge and who will appear before this judge again, would do something in closing arguments that that most legal scholars would probably say the judge's decisions aren't proper for the jury to consider towards the end.
Professor Stephen Wright, thank you so much for joining us. We appreciate your legal insight.
My pleasure. Thank you for having me.